Guarda.
Good morning, good afternoon, and good evening to all of you joining us today for this third edition of the FIFA Football Law Annual Review. Due to the still ongoing COVID-19 situation, we are meeting here today again online. You can follow us in Spanish, English, and French. All presentations will be given in English with simultaneous interpreting into Spanish and French. All presentations, as well as the recording of the event, will be available within this week on legalfifa.com. Please send us in your questions to the email that you see here below, annualreview@fifa.org. Send us in as many questions as you want, and each speaker will answer your questions after his presentation. As to the agenda, we will be here during 2 days. Day 1 will be dedicated to the review of the year 2020, with the complete review of the legal and compliance activity, as well as with the activity and the leading cases of FIFA's decision-making bodies, as well as with outside football matters, a review of the year 2020. Day 2 will be completely focused on the latest reforms and the reforms yet to come. We will get an insight into the latest evolutions of the regulations in relation to the new eligibility rules, female players, the amateur players, and the challenges ahead of the reforms. So now let's start with the official welcome of the FIFA president, Gianni Infantino. Gianni, over to you.
Thank you very much, Maya. Thanks for handing over the floor to me, and a warm welcome, of course, to all those who are watching us live, or maybe, as you were saying, recorded if they cannot sleep one of the following nights. I can warn you already now, if you are watching this because you cannot sleep, you will certainly not fall asleep now, because what you will hear in the next few hours today and tomorrow will be extremely, extremely interesting and extremely important as well. So good morning, good afternoon, good evening, buenos dias, buenas noches, bonjour, bonne nuit to everyone wherever you are around the world. I was saying it, you have 2 exciting and interesting days in front of you. Of course, exciting and interesting for lawyers. I used to have studied law some decades ago, which doesn't make me feel younger, but still, when you study law, when you practice a little bit, good or bad, I don't know, but when you practice a little bit law, you remain always somehow connected to the law. And I would like to start by, after welcoming you, thanking those who are in charge of this seminar, Maya, Emilio, Alistair, and of course the whole team in FIFA and outside FIFA who is helping us to do what? Well, to change FIFA, because this seminar, this international football law annual review from FIFA is a part of what the new FIFA is about. It's part of the new transparency, it's part of the new openness, it's part of the new professionality we want to give to the world. I was saying, when I started to study even sports law was not even existing, and now we speak even about football law. I used to say, and this maybe is as a little anecdote, I used to say in some conferences I was invited to, that many of the problems that football has experienced were due to the fact that lawyers started to get involved or interested in football matters. Now, this was the case some decades ago, but today, thanks to seminars like this one, we can actually not create problems, but solve problems, or helping to solve problems, because we are transparent, because we are open, because we share what we do, and because we can make everyone out there in the sports law and the football law business know why we are doing certain things, where we are coming from, where we want to go, and take on board as well, of course, the input that we are receiving from all of those of you who are listening to us, all of those of you who are participating in our activities, because clearly we are far from being perfect, but we want to try to be better and better. And that goes only through being transparent, being open, exchanging with you, presenting to you what we are doing. Now, of course, we are doing this in a particular period as well. 2020 has been a very difficult year, has been a year which has brought to us many, many challenges with the COVID. And from a legal perspective as well, from a regulatory perspective, as the governing body of world football, we had, of course, to amend various regulations. And you will go through, of course, some of them, not only regulations on the pitch when it comes to format matters or laws of the game, where we increase the number of substitutions, for example, to care about the health of players, but also, of course, from the legal point of view, trying to do what? Trying to help the member associations of FIFA, the leagues, the clubs, the players, to find ways to navigate through this highly complex situation, which is not yet over, but which certainly has disrupted our day-to-day activities. Now, when it comes to the last year, let me mention, even if it's not strictly linked with legal matters, but let me mention, because I think it is important, the solidarity and unity which has characterized international football in the last year. We have in FIFA been able to set up, thanks to the very solid financial situation that we have and very robust figures, we have been able to set up a COVID-19 relief plan to the benefit of our 211 member associations all over the world. A COVID relief plan of a global value of $1.5 billion. I think no other sports organization, and maybe not many governments even around the world, have been able to put in place such a plan. But it's a plan that is necessary not to finance the top professional game, but to keep football alive, to keep the ball rolling, to focus on women's football, to focus on youth football in all the countries all around the world. So we had also for this step, of course, to care about the legalities, to make sure that good governance is applied, to make sure that if money is distributed, that if money is invested, it goes where it has to go. And we have been working on this particular topic. We have as well, and this will be presented to you later today and tomorrow, we have as well had to deal with some temporary amendments to some of our regulations. For example, a very topical issue currently, now these days, is the release of players for the national teams. We are aware that in a pandemic situation, we cannot simply request clubs, players, associations to apply the same rules that we were having before. We had to relax a little bit the rules, to be aware that we are living in a pandemic, to be aware that health is the top priority that we have, and this needs to guide us in whatever we do, of course, putting in place necessary protocols to allow national team football as well to continue as much as possible. We had to introduce as well some temporary amendments to the transfer rules, to the transfer system as such. And obviously one of the consequences of the pandemic more generally was that for the first time in 10 years, at least, the figures on transfers and the transfer fee, so to say, figures went down, maybe not as strongly as one would have imagined. You will hear about that later on, so I'm not going to focus on that, but definitely still a good, I don't know, 20, 30, 40%, depending on the parts of the world and the regions we are speaking about, which is normal due to the circumstances. We have as well, and that was not linked to the pandemic, but linked to the football development and the vision to globalize football truly and really. We have amended the eligibility rules for national teams, because it is important that in a globalized world where players are maybe from a nationality but are born in another country, are developed in a third country, or have two parents from different countries, or have 2 or 3 different nationalities and passports, and they are given the opportunity to choose their country and maybe even to change if certain strict conditions are met, but to change the countries for which they can play, because national team football is, together with club football, of course, part of the globality of football, and we need to take this as well into account. This is a very practical, a very football related aspect, but we need also there regulations, we need laws, we need to address, and we had unfortunately some situations in the past, we need to address particular hardship situations that made us go in that direction. Projects for the future as well, a new football tribunal that we are setting up. At least it's a new name for that. Some of the things that this football tribunal will be asked to do are things that some committees and chambers in FIFA are already doing. Something new, particularly related to agents, will come on top of that. It was just approved at the end of last week by the FIFA Council, will be submitted to the Congress. Hopefully it will pass, but again, you will hear about that in a few minutes or hours. A project for the future as well is the FIFA clearing house. I've been advocating for some years now already that many of the problems linked with FIFA or linked with football more generally are linked to the money flows. And if there is transparency, if there is good governance around the money flows on transfer matters, for example, we go a long, long way in addressing issues which unfortunately are always creating negative headlines for football. So the FIFA clearinghouse, focusing at the beginning on training, compensation, on solidarity mechanism, but thereafter probably being broader than that, will in a first step make sure that training clubs receive what is due to them, but creating more transparency and more openness, which is the theme as well of this seminar, of this conference all together. So, dear friends, dear sports lawyers around the world, 2021 will be an important year for the world, recovering hopefully soon from the pandemic. Will be an important year for the world of football as well, coming back to global competitions. We started with the Club World Cup in Qatar at the beginning of this year. We'll have some other competitions around this particular year at the world level. At national and continental level, of course, competitions have resumed earlier. At global level, it's a bit more complicated. But it is a year which hopefully will help us coming back to some sort of a normal life. Part of a normal life is also the legal matters surrounding football. We have some news to share with you. As always, we are interested in your feedback, in your critical feedback, but hopefully also fair feedback. And with this in mind, I'm sure you can witness in our company some very, very interesting 2 days. And I'm sure that this will help you all not to create problems to football, but to solve some of the football problems. So thank you very much for being here. Thanks for your interest. Thanks for your attention. Our team is here with you. It has been a pleasure and an honor for me to say a few words to you, and I wish you all the very best. Thank you very much, and I give back, I think, to Maya, I guess. Thank you, and bye-bye.
Thank you very much, Danny. Also, from our side here from FLAR, we wish you tomorrow a very special day. And now let's start with our first speaker. It's a pleasure to have our first speaker to give you an overview of 2020 and the outlook for 2021 of the FIFA Legal and Compliance Division. Here with us today we have Emilio Garcia, FIFA Chief Legal and Compliance Officer. Emilio, over to you.
Buenas tardes, good afternoon, everyone from Zurich. Good morning, good evening, whenever you are in the world, and welcome to the third edition of the Football Law Annual Review. It's a great pleasure to be back. Unfortunately, as the President has just said, we are forced to do this online. So a few months back, when we were presenting the second edition of the FLAR, we thought, well, maybe in 2021, we will be in lovely Argentina, in Buenos Aires, having our FLAR there. But unfortunately, given the circumstances, we continue to do this. But I'm always very positive. So I hope that in 2022, finally, we will visit our friends in CONMEBOL, in Argentina, in Buenos Aires. And the fourth edition will be from Ezeiza rather than from Zurich. In any case, we have a very intensive and interesting agenda ahead of us these 2 days. So first, looking back to 2020, going through all the reforms, going through all the topics and questions that were highly relevant in this year. And then tomorrow, we will be presenting topics that we are working or have been passed during the last months. So I promise to be very, very brief, just a general overview about 2020 and some ideas for 2021. Thanks, obviously, to our President, Gianni Infantino, for being with us today. Every year he is with us in the FLAR. He's always pushing and supporting these kind of activities. So, Mr. President Gianni, thank you very much. And as Maya said, you know, all the best for tomorrow. Happy birthday. You are reaching more or less the barrier of 30, 35. So we all wish you all the best for tomorrow. Let's move now to the topics. Overview about 2020. I've divided this quick presentation on 3 different topics when it comes to 2020, our regulatory activity, our legal education activity, and also the report or transparency activity. And then I will spend a few minutes trying to give an overview about what we are cooking right now for 2021. But let's start with the regulatory activity in 2020. So as the President said, you know, 2020 kept us extremely busy. The year was completely unexpected, the situation, the circumstances. So it goes without saying that the world has changed since March 2020. But also, of course, when it comes to our football regulatory activity, everything has changed. So over the last 12 months, we have been really focused on the football regulatory problems around COVID. We think that we have been quick when reacting to the pandemic. So, you know, in a few weeks, we were able to put in place some guidelines and general rules to be applied all over the world. You know, we had more than 60, 70 seminars with MAs, with clubs, confederations, player unions all around the world, trying to give clarity in a very particular moment. We are more or less satisfied with the outcome of these rules, or these temporary rules, particularly the guidance and the guidelines concerning COVID, the Q&A document. And this is thanks to the cooperation with the football stakeholders. So we are here, we are trying to help, but we cannot achieve this without our colleagues and friends from the World League Forum, from FIPRO, from ECA, from the confederations and MAs. But obviously, 2020 saw the transfer regulations, the so-called regulations on the transfer of status and transfer of players changing every month. So I'm very sorry for this. We are very sorry for this. But the situation forced us to take measures every week, every 2 weeks, every month. And that's why I cannot remember exactly, but maybe in 2020 we had 3 or 4 different editions of the regulations on the status and transfer of players. I know that sometimes it is not easy to follow this. Thank God now we have this legal.fifa.com, so we upload everything there. But I apologize in advance and we apologize in advance for having changed every month, every 2 months. It's also not good for you, but also it's difficult for the administration. I'm looking now at Erika, that she's following FLAR from the meeting room, and and the guys and colleagues in the player status department, also in the professional football department, James and the team working, every month, every 2 months with a different set of rules, or at least partially. So it's not easy for the users, for the clients, but it's not easy also for the administration. But again, we were forced to do this, and I think that the outcome has been more or less okay. As the president also highlighted, 2020 saw the new FIFA eligibility rules to play for representative teams. We'll have a comprehensive presentation from James Kitchen on this very specific topic, a very particular topic. But after 10, 12 years, we were brave enough to set up a kind of working group in 2019, beginning 2020, and then to propose changes to be voted on the FIFA Congress, the online FIFA Congress in May 2021. So I will refer to this point later on when presenting the transparency and the reports. And finally, when it comes to football regulatory aspects, obviously we passed the FIFA Anti-Doping Regulations 2021, fully in line with the World Anti-Doping Code, the so-called WADA Code. So, and this is more or less the end when it comes to this part of the presentation, football regulatory aspects. But I would like to conclude this chapter by referring to the FIFA Legal Handbook. So I think it was in September, so we launched this digital tool for the MAs, for the confederations, of course, for lawyers. It's a free document that you can download from legal.fifa.com, in which you can find all relevant FIFA regulations, circular letters, and also standard documents. Obviously, we have produced this in English, French, German, and, of course, in Espanol. Second part of this first chapter, transparency and reports. We have been working hard in 2020, even though we were forced to work from home 95% of the time, but the team was working hard here in order to start working on these transparency reports that is, as the president mentioned, crucial for us. And for the first time, 2022 saw four different reports referring to anti-doping, referring to disciplinary and ethics, referring to intermediaries, and referring to the activity of the player status department. And of course, we are fully committed to continue with this. So 2020 was the first year, but in 2021, and as from now on, we are going to publish these 4 reports every year, looking at the activity of the player status department, the intermediaries report, and as I mentioned, anti-doping, and of course, the activity, the always beloved activity of the disciplinary and ethics commissions or body of FIFA. Also, in terms of reports and transparency, as from 2020, we have the intention every year. So again, 2021, we'll see these changes. So we have the intention to publish 3 different reports. The first one will be the Global Transfer Report that we used to publish in January and or February, looking back at the last year, in this case, 2020. Then, a brief report after the January transfer window, and then a brief report after having closed the so-called summer transfer window. Summer in Europe, but summer is not summer in South America, for instance. But, we used to call summer transfer window. So these are the 3 kind of reports that we are fully committed to continue publishing on legalfifa.com about the transfer market activities as from 2020. Also in 2020, we have launched and presented different commentaries and guides on different topics. First of all, we published this guide to submitting a minor application. So Article 19 is always complicated, and the administrative aspects of Article 19 are sometimes very complicated. Thanks to the team in player status, Erika and Julien and the whole team, they did a great job, and they prepared this guide that it is also in Spanish, in French and German, and is really useful for our member associations, and also, of course, for minors or family or the family around the minor in order to submit this application. Then, in the context of the new rules approved by the Congress in 2020, we published this commentary on the rules governing eligibility to play for representative teams, also a very gray and sometimes very complicated area. I hope that this commentary can provide you with more clarity when it comes to these aspects. And finally, so also in this context, this guide to submitting a request for eligibility or change of association. These 3 materials are also available at legal.fifa.com, and we are the product of these months working from home, trying to develop the concept and trying to help MAs and confederations. Turning now to reports/transparency and professional football, there are some other amazing projects, but I would like to introduce or to refer today to these 2 that you can see on the screen. The first one is the Professional Football Journal, the FIFA Professional Football Journal. So every 4 months in a digital format, Ornella and the team, they are working on this tool that is also very useful for clubs, also for national associations and confederations. And very recently, Ornella and the team, they published the 2020 Global Competitive Balance Report. It's an amazing document. I invite you to have a look at this report, again, available on our website. You can find figures and information about these aspects all around the world. So from the Spanish league to the Japanese league, from Argentina to Canada. So there are a lot of information around football on this report. And finally, when it comes to transparency and reports, we were able to put in place to publish, again, in Spanish, French, English, and German, for the first time, the first ever FIFA Compliance Handbook. So a tool in order to help MAs, in order to help confederations when dealing with compliance aspects. So here the division is legal and compliance. We are also very active. We launch and we organize the 3rd compliance summit also online a few months ago in October, if I'm not wrong. And one of the best documents that we have published in 2020 refers to this compliance handbook, also available on FIFA.com. Finally, looking to 2020 in terms of legal education. So, we launched some interesting programs, the FIFA Executive Program in Anti-Doping. We are running the 2nd module right now. Just finished the 1st edition of the Executive Program in Sports Arbitration. And again, we are fully committed to continue with the second edition in 2021. So here, Theo and Maja, the whole team in the division, they are working hard on all these projects. Diploma include management. Just the first module finished a few days ago. Ornella and the team with amazing participants, so World Cup winners, former players at international level, club managers, really a very nice program that, again, we are fully committed to continue in 2022 as well for the second edition. And finally, the so-called Football Law Talks. So every month we have a guest speaker coming from football or football activity and talking about relevant matters. Other projects, in order to close 2020, I have to say that we are very happy and very honored to having launched this FIFA FFP, the FIFA Fund for Football Players, a very nice and social project in cooperation with our colleagues in FIPRO. We are going to invest almost $20 million over the next 2 years, helping helping players in difficult circumstances all across the world. The first series of these decisions will be passed next week, and then very much looking forward to continuing with the 2021 and 2022 project of this FIFA FFP, FIFA Fund for Professional Players. Again, all this info, analysis and other materials can be found on legalfifa.com. We are also working on a new webpage, a little bit different, the same content, but visually a little bit different. But, you know, when it comes to IT matters, it's always complicated. I'm a lawyer, just a lawyer. IT is a different world. But for sure, 2021, we'll see a renovated, but again, more or less with the same material, legal.fifa.com. Well, what can we expect in 2021? So time flies. We are in March 2021, mamma mia. So, but what can we expect for this year? As the president has just announced, we would like to change a little bit the structure of our judicial bodies in charge of the football disputes. And that's why we are going to set up what is called the Football Tribunal, obviously subject to the final approval of the Congress. The FIFA Council passed this decision on Friday, and now the 71st FIFA Congress on the 21st May 2021, the members' associations, they have to pass this decision. But if this decision passes, the idea here is to reconfigure a little bit the dispute system at FIFA with this football tribunal and 3 different chambers: the classical, the legendary dispute resolution chamber, then the player status chamber. So you will not be the player status committee. So the player status committee will not be longer a standing committee of FIFA, will just be a pure adjudicatory body, internal chamber. And also the third box of this football tribunal will be the so-called agent chamber. And the members will be in charge of all the disputes in the context of the upcoming FIFA agents regulations. We have the intention to pass to propose to the Council the procedural rules to be approved in May 2021. So if everything goes in the right direction, as from 1st July 2021, the Football Tribunal will be set up with these 3 different chambers that, as the President said, is more or less the same, a slight difference, particularly the agents chamber. But you will get more news most likely after the Congress, and we will be very active promoting the new chambers and the new competence after the Congress. Also, in this context, the Football Tribunal, the new umbrella, the new setup, I know that FIFA joins the lovely world of emails a few years ago. Until 2016, 17, we were very well known for not accepting emails, just fax. So we arrived late to the world of emails, but we don't like to arrive late to 2021. So that's why, in 2021, we have the intention to launch the so-called FIFA Legal Hub, the FIFA Legal Portal. What does it mean? It means that as from 2021, and most likely in 2022 will be mandatory, all the interactions with the DRC, the Player Status Chamber, the Agent Chamber, the Disciplinary Committee, the Appeal Committee, the agents, so the licensing, et cetera, all will be done throughout a legal portal. So, we are not going to welcome emails anymore. So you and us, we will be forced to go through the portal. You will get access to your files. You can see the status of your case, et cetera. So we would like to change a little bit what we are doing. Again, email is fine, but the email was useful in 2000. We are in 2022, 21. So that's why we would like to change the way in which we interact with you, and this FIFA Legal Portal, FIFA Legal Hub, should be a reality in the last part of 2021 and should become mandatory for all of us for interacting with FIFA in all kinds of legal proceedings as from 2022. But again, more news soon after the summer. I know, and we know that a few months ago, we announced the FIFA commentary to the RSTP, the transfer regulations. I'm very sorry. We have been really busy with all these things around COVID. We delayed a little bit the project. The idea was to launch the project in January, February 2021. We are in March, but I can tell you that the project is in the final phase. Translation into Spanish, French, and German. So it makes no sense to launch the English version and then after 2 or 3 months, the Spanish or French or German. We would like to do this all together, but for sure in 2021, you will see the commentary to the RSTP, also with comments on the new chapters, the new Annex 8, on coaches that the colleagues Marco, I think, will present tomorrow, and also, of course, all the new regulations and articles concerning female players. So again, hope that before summer or just after summer, this commentary is out in the 4 FIFA official languages. And finally, as the president also highlighted, working hard on the FIFA clearinghouse. I think Ornella will provide you with more details tomorrow on her presentation. So, and we expect to close this project and to present this project in 2021, exactly the same with the so-called FIFA agent regulations. We are now finishing the consultation process with MAs, with the confederations, with agents group. So the regulations are almost ready. And we expect to refer these regulations to the Council this year, with the idea in mind that the regulations will come into force as from 1st January 2022. And finally, last but not least, as we say, in terms of education, we can present the FIFA Global Integrity Program, just launched days ago, 3-4 days ago. I'm presenting this, something like we are going to do. Indeed, the program is now running. So it's a global initiative from FIFA in cooperation with the MAs and the confederations to extend our knowledge and extend our capabilities in terms of integrity, the fight against match fixing. Again, the program is running. The first module is moving ahead with the Asian Football Confederation, but also a very nice and social, I would say, initiative from our side in 2021. That's all from my side. Again, as I mentioned in the beginning, we have planned a very interesting FLAR for 2021. So we have now good presentations and nice presentations from player status department, cash cases, disciplinary and ethics. And then our very good friend, Sam Cottrell, will introduce sports law matters in 2020 outside football that, you know, as the president mentioned, it's not only football, but it's football, but, you know, sports law is more than football law. And that's why we invited Sam to give this presentation later in the afternoon or in the evening. And then tomorrow, the team will be focused on the new decisions and regulations passed in 2020, starting with the amendments to the statutes and the rules for representing national teams. Again, I wish you a very nice FLAR. Today's talking about football law and sports law. It's really nice for those who love this. Definitely, I love this. I'm very passionate about all these matters. So I will be here with all of you, with Maya, with the legal team. That's all from my side. Thank you very much, Maya, and enjoy the day. Thank you.
Thank you, Emilio. We are aware that it's not working properly, so I have been receiving several messages, and I also have noticed it in here, so I know that the YouTube stream is not working properly. We do apologize for this. We know that whoever received the link of Zoom is able to follow us, and there it's actually better the connection. Our people from IT are looking into this and are doing the best they can to make sure that you are able to follow us. Please also don't forget that we are being recorded. So I hope that if you have been missing the first few slides from Emilio, anyway, all the slides that you have seen so far will be published. So we will have them on legalfifa.com. And I hope that also somehow we'll be able to show to you the recording. Having said that, I hope that it works, and I'm very happy to present to you my next speaker. It's Erica Montemor, the head of player status, and she's here to give us an overview over the activity of the player status department, as well as the leading cases of her department. Erica, over to you. Thank you.
Thank you, Maya. Hello, everyone. It's a pleasure to be here again to present you the activities of Player Status Department. I have to say, if something can make me more nervous than speaking in front of a live a live stream, is to follow the president and Emilio Garcia. So I'll try to do my best here. But what I want to say is that, jokes aside, that there has been a very busy year, as you see from Emilio and from the president. He showed all the programs, activities, and publications issued by the legal division. And Player Status Department was in the middle of most of it because it affected the regulations. And so I will give you today to show you how busy 2020 was because of COVID, but I would like to say also in spite of COVID. So here, before starting, I would like to take a moment to thank my team, to thank the Player Status Department team that really showed commitment and worked through a very busy year with all the challenges we had due to COVID. My presentation today, I will divide in two parts. So first, I will show you a review of 2020, and here basically show you the numbers in contrast with other years. And then also touch up in some of the latest amendments, the ones that will not be presented by my colleagues, so coaches, female players, and execution will be presented tomorrow, but I will pass on some important amendments that were through. And on the second part, I will present you relevant decisions adopted by the FIFA deciding bodies, the Dispute Resolution Chamber and the Player Status Committee. Okay, let's start. So we can see here in the numbers, and here we'll start with first the claims of solidarity mechanism and training compensation. They are lodged and processed via the transfer matching system, the TMS. And as you can see, in 2018, there were around 1,200 new claims lodged. If we go to 2019, we can see a 26% increase. there were more than 1,500 new claims in that year. But if we move forward to 2020, we see there was a new record. More than 2,000 new claims were lodged and processed in the transfer matching system, with a 32% increase of claims. As you can see, 2021 has also started in full power, and in the first 2 months, we already had more than 300 claims lodged, which indicates that we're going to have a busy year ahead. Now moving to the contractor disputes, here we're talking about all claims involving players, coaches, clubs, and member associations. Here as well, we can see that in 2018, there were more than around 1,000 claims lodged during that year. And in 2019, we saw there was a 20% increase, and we had 1,200 around claims lodged before either the DRC or the PSC. But then in 2020, we have witnessed a record increase. We had more than 40% of increase in the new claims, and we reached more than 1,700 new contractor disputes lodged before one of the deciding bodies. Here, I would like to refer to a particular period of time that between March 2020 and December 2020, we really saw the impact of COVID, in particular in employment-related disputes between players and clubs, and disputes between clubs. As from March 2020, in comparison to the first 2 months, there was this further increase of 20%, reaching the 40% that I mentioned before. And finally, in 2021, you can see already that the first 2 months were also quite busy, indicating that this tendency is for now to stay. Now, of course, going back. If we're talking that many new claims were lodged, that also means an extra effort needed to tackle the workload and to make sure that we continue to provide the parties and the stakeholders with an efficient dispute resolution system. So here, as presented last year, so here I'm also making reference to the amounts showed last year in the FLAR. In 2018, around 1,100 decisions were passed. Of course, in 2018, with the big effort to tackle the backlog, more than 2,000 decisions were taken by the deciding bodies, the DRC and the PSC. And now, no longer we have a backlog, but as you saw, we have a really big increase on new claims, and that meant that the DRC and the PSC had again to analyze and decide on more than 2,000 decisions. So 2020, we had 2,109 decisions passed by the DRC and the PSC. So I said it was a busy year because of COVID, but in spite of COVID, we managed to continue to maintain the same rhythm and provide the parties and the stakeholders with an efficient dispute resolution system. And here as well, I take a moment to thank, of course, the members of the Dispute Resolution Chamber and the Player Status Committee for analyzing and deciding on more than 2,000 cases. Now, moving to the next topic, I would like to speak about the transfer of minor players. And here as well, as you can see, it was a busy year. The Player Status Department has dealt with more than 4,000 applications, passing almost 3,900 decisions. The great majority of the applications are still under Article 19, paragraph A, which means the move of the parents for reasons not related to football. Here again, also take a moment to thank the team, and also to say that despite the COVID, we managed to improve the efficiency and deal with the applications in a more efficient manner. Now, 90% of the cases are resolved in less than a month, and the average between the receipt of an application and a decision being taken is 12 days. As you can see also in my slide, you can notice that the time to process an application is directly impacted by the parties, meaning that whenever we need to ask for additional documentation, this application will take twice the time to be decided. So a complete claim is dealt with in half the time in comparison to the ones that we need additional documentation. So this, I would take the opportunity to refer to what Emilio has said. So he showed you the guide to submitting a minor application. And this is an important tool for the parents of the minors, the clubs, and the association, in the sense that if an application is submitted and is complete, it will be able to provide you the decision in a more swift manner. And that's why I encourage you to read the guide prepared by the team. If we continue, still about minors, is to say that we can clearly see the impact of COVID. As everybody know, in the reports that were issued by the legal division, COVID outbreak had a concrete impact on international transfer, and obviously also in the transfer of minor football players. The images here speak for themselves. I'm sorry, I hadn't changed the slide. Yeah. So the images here speak for themselves in the sense that the first time in history that we received less cases compared to the previous years. So there has been a steady increase of applications throughout the years, as you can see. And 2020, there's a clear impact where the tendency goes to the opposite direction. We can also see in the month by month that this continues in 2021. Since we are talking about the effects of COVID on our daily work, and again, as showed by Emilio, it was a very busy year providing service to the stakeholders, handling validation exceptions, manual transfer windows, ITC procedures, eligibility matters, and replying to many queries related to COVID-19. Luckily, we were ready to provide ongoing support during the whole pandemic to 118 member associations to change their registration periods that were affected by COVID-19 or their season dates, and also to support on release of players association teams. As the president mentioned, it took an effort from everybody together, and also the temporary amendments to make sure that the players could play for the national team. Now that we finished with the numbers, let's go to the relevant amendments. And here, as Emilio said, we had several amendments during 2020. And most of them were needed. We needed to change temporarily the RSTP to make sure that we could cope with COVID. And this basically affected exception to registration periods, changes related to the release of players, and that is the reason why 2020 was with many additions of the regulation on the status and transfer of players, which I will now refer to as the RSTP or regulations. But there is one amendment that I will speak today that will not be explained by my colleagues, which is not COVID related, but is about transfer of minor players. So in January 2021, a new amendment came into force related to the transfer of minor players. And the background of this amendment is the UK and Brexit. So as you know, UK is one country with 4 separate MAs, member associations. And there was legal uncertainty concerning the effects of Brexit and the imminence of UK leaving the European Union. So the international transfer of minors within the UK will no longer be subject to the so-called EU exception under Article 9, Paragraph P of the RSTP. So this amendment to the 19, which we'll see in the next slide, aimed to exactly avoid that a minor would be unable to transfer between the same country. I would like to clarify that obviously this amendment does not apply only to the UK scenario, but to any other situation where more than one member association is domiciled in the same country. So moving to the next slide, we have the new wording of Article 19. And here we see that under Article 19, Paragraph P, we have the exception that applies to transfers within the territory of the European Union or the European Economic Area, but also now, as of January 21, it also applies to transfers between 2 associations within the same country. Just to clarify, of course, the same obligations that existed for the clubs are applicable also to the transfer between the same country, meaning that the club must provide football education in line with the highest national standards, academic education, and accommodation. Okay, now I will move forward to the procedural rules. And here I will speak about the most relevant recent amendments we had that entered into force in January 2021. So first of all, to explain why did we amend again the procedural rules, here the amendments were to reflect the practice of the FIFA administration and the jurisprudence of the DRC and the Player Status Committee, and to provide legal certainty and more efficient service. So the first article amended was Article 9, Paragraph 4, to make it clear that whenever an opposing party, meaning here the respondent, wishes to lodge a counterclaim, the club or the player or the coach, the party must do so within the same deadline given to reply to the claim. Also, this counterclaim must fulfill all the requirements to any claim lodged before the Player Status Department and needs to be compliant with Article 9, Paragraph 1. On the same note, in case it is not a counterclaim but receive parallel claims regarding the same contractual disputes, they will be dealt with as claim and counterclaim. This is to avoid delays or any unnecessary exchange of correspondence, as well as guaranteeing due process and obviously avoid to have controversial decisions. Now going to the next amendment is Article 9, Paragraph 1, which now has a new letter, J, and it refers to the bank account registration form. And here again is also to provide a more efficient services. So as you know, since June 2018, Article 24B is applied, meaning that the decisions taken by the DRC and the PSC, whenever 24B is applied, will be executed by the player status. And already in the decision, it was foreseeing the consequences for the non-fulfillment of the decision. Well, the problem that we encountered was that to count the 45 days, we would need the information from the creditor that had notified the debtor about the bank details. So we will need this information before being able to start counting 45 days and execute the decision. For that reason, and also in accordance with the new Article 24 bis, which will be explained by my colleague Molly, now the new claims as of January 2021, apart from all the requirements of Article 9, Paragraph 1, also need to have this bank account registration form, which is available in legal.fifa.com. And this way, we can then pass a decision and already from the date of the decision, start counting the 45 days. And also, this will come from my next slide in the proposals. So here, another change is Article 13, which is the article that talks about proposals. As you all know, proposals were only used before for cases of solidarity mechanism and training compensation. And this was applied for cases where there are no complexity and or there was an established jurisprudence. Well, now, as of January, this is also applicable, January 2021, to cases of contractual disputes. Obviously, that means only cases of non-complexity and that has an established jurisprudence. So to put an example, for salaries that are unpaid and that are clearly established in the contract or installment of a transfer fee, in these cases, the FIFA administration can and will use the proposal to the parties. What is important is that now, whenever the proposal is possible, we will send the claim to the respondent and we will send the proposal together with both parties, and they have 15 days to either accept or reject the proposal. In case the respondent wishes to reject the proposal, should already send as well its position to the claim, because this is the same deadline to reply and do the proposal. In here, the same as for solidarity and training, whenever the parties accept or do not reject the proposal within the deadline, this proposal will be considered accepted and binding in all the parties. What is new in Article 13 as well is the fact that after this deadline, a confirmation letter will be issued to the parties and 24 bis will apply. So I think it's important for the parties are aware of that, and this will for sure bring more efficiency to us and also allow us to focus on the most complex matters to be submitted to the Dispute Resolution Chamber and the Player Status Committee. Now moving on to the part of the leading cases. So I finished with the numbers and the recent amendments. I will now speak about the leading cases. And the problem is, how do I pick the most interesting cases out of 2,000 decisions? So since the most spoken topic has been COVID, and as Emilio presented, there were many documents issued by FIFA in this regard, I decided to choose cases where the DRC analyzed the unilateral termination of a contract in connection with COVID-19. So in this first case, we have here the facts of the case. In here, there were several salaries unpaid by the club. And on 14 March 2020, the player, on 14 March in 2020, the club canceled all trainings sessions as a result of the pandemic. On that same date, the player put the club in default in writing in accordance with the RSTP and Article 14 bis, giving the club 15 days to remedy the default. The club, unfortunately, did not pay the salaries within the deadline. And following that, on 30 March 2020, the player terminated the contract, invoking just cause to do so. Subsequently, the player came to FIFA and lodged a claim for breach of contract against the club. And the club replied to the claim. But here what is interesting is that the club did not contest that the amounts requested by the player were outstanding, but the club argued that the termination was without just cause because it was done during a force majeure situation while the contract was actually suspended. So here we have the work of the DRC. The members of the DRC had a lot of cases to go through. And in cases of COVID, a lot of documents to analyze. So first of all, while analyzing whether the contract was terminated with or without just cause, the DRC first referred to the COVID-19 guidelines issued by FIFA, as well as the FIFA COVID-19 FAQs, which were presented by Emilio before. As to the force majeure invoked by the club, the chamber recalled that FIFA did not declare that the COVID-19 outbreak was a force majeure situation in any country or territory, as well as that any specific agreement was impacted by the concept of force majeure. What does that mean? In summary, translating, it means that it is the responsibility of the party invoking force majeure to prove that such situation occurred and also draw the consequences from it. And at the same time, it means that the dispute resolution chamber must analyze on a case-by-case basis, considering all the specific circumstances and the documentation provided by the parties, whether or not there was a situation of force majeure. The DRC also highlighted in this decision that the two documents issued by FIFA related to COVID-19 explicitly indicated that they were only applicable to the unilateral variation of existing agreements. That means that the guidelines are only relevant if a termination of a contract occurs following a unilateral variation of that contract. Otherwise, the unilateral termination of a contract continues to be analyzed under the RSTP and the jurisprudence of the DRC. In the present case, the DRC considered that the two salaries were, in the present case, there was no variation prior to the termination of the contract, and therefore only the RSTP applies. That being said, the DRC analyzed the facts and evidence in the case, and first of all, considered the two salaries were outstanding already before the suspension of the football activities, and the club failed to provide any justification why it did not fulfill with its contractual obligations. Also, the player had put the club in default, giving them the possibility to remedy the default in 15 days in writing in accordance with the RSTP. Therefore, the DRC concluded that the player had just cause to terminate the contract on 30 of March 2020 based on Article 14 bis, paragraph 1 of the regulations. The club was therefore liable to pay the outstanding remuneration to the player as well as compensate the player for the breach of contract. Here, going to Article 17 of the RSTP, first of all, the dispute resolution chamber analyzed whether the contract had a compensation clause. Since the contract did not have one, the DRC calculated the compensation based on Article 17. Considering the player remained unemployed in this case, the compensation award was the residual value of the contract according to Article 17. Now I'm going to go to the second one, but I'll do a short break. Maya, how much time do I have? 10 minutes, okay. So now I'll finalize with the second case, try to be fast so we can also open the floor for questions. In this second case, we will see that the same on 16 April 2020, the club suspended the contract, and in this case also the salary payments, and referred to a national law, a national government emergency order. On that same date, the player put the club in default, notifying the club in writing, the same as the other case, and granting the club 15 days to pay the outstanding salaries. Since the club did not pay the unpaid salaries, on 4th May 2020, the player terminated the contract, invoking just cause. What we see here is, again, the player lodged a claim for breach of contract against the club before FIFA. And the club also did not contest that the amounts were requested by the player were outstanding, but in this case argued that at the time of the termination, the contract was suspended, rendering the termination without effect. The player, for his part, argued that the COVID-19 could not be used as an excuse, since the salaries that he was claiming and on the basis of which he had terminated the contract were already outstanding before the suspension. So here, I'm not going to go through again everything, just to remind that the DRC referred to the FIFA COVID-19 guidelines and COVID-19 FAQ. And as in the previous case, members of the DRC recalled that both documents only apply to unilateral variation of existing agreements. In the present case, the DRC considered that the decision of the club to unilaterally suspend the contract and the salary payments should be regarded as a unilateral variation to the contract, and therefore it needs to be analyzed under COVID-19 guideline. So both the documents are applicable here. The DRC, analyzing the documentation presented by the club, established that based on the documentation, according to the national law, it was indeed possible to suspend the contract in case of a temporary interruption. Also, during that suspension, in their emergency order, the player was entitled to receive up to 75% of his income. Also, the authorities in that country had declared a state of emergency until 31st May 2020. And finally, that the competition will resume as of June 2020. So the DRC considered that taking into account the specific circumstances of this case and all the documentation provided, despite there was no agreement between the parties, the club demonstrated that it was allowed to suspend the contract while referring to the player to the possibility to collect part of his salary from the government. But that being said, as we saw, the DRC considered that the club did not bring any valid arguments to justify why it failed to pay the salaries, which were already due before the suspension. Also, the chamber considered and accepted the argument of the player that the outbreak cannot be used as an opportunity to escape debt that fell due at an earlier stage than the actual suspension. Also, as to the argument that the player could not terminate the contract during the suspension, it was considered that this argument could not be upheld and that the club admitted not respecting contractual obligations. Therefore, in accordance with the principle of pacta sunt servanda, the club had to comply with its obligations. Therefore, the DRC concluded that the player had just cause to terminate the contract because in that moment of the termination, more than 2 salaries were overdue, according to Article 14b's paragraph 1 of the RSTP. In the same sense, the player was also entitled to receive the unpaid salaries and compensation. What is interesting about this case and why did I choose to show 2 cases on the same topic is because in this one, there's something interesting about the unilateral variation. As we saw, the unilateral variation did not change the fact that the player had just cause to terminate the contract, but it did have an impact on the residual value of the contract. So first of all, since the parties did not agree on a compensation clause, the same as the previous case, the DRC applied Article 17 for calculation of the compensation. Since the player remained unemployed, the compensation corresponded to the residual value of the contract, which would run until June 2022. The DRC, however, considered that should not take into account the month of May 2020, because this month, according to the order of the national law, was to be paid by the government to the player. For this reason, the residual value of the contract was considered by the DRC as from June 2020 until June 2022. This decision has been appealed and it's currently a CAS. So maybe next year I can tell you what is the outcome and what is the analysis of CAS concerning the COVID guidelines. To finalize, and before opening questions, I just want to say that from both cases, we can draw some conclusions that has been in all the DRC meetings where we have our cases with COVID, that this is always referred by the DRC. So first of all, that the FIFA COVID guideline and FAQ did not declare force majeure in a specific country or territory, as well as needs to be analyzed on a case-by-case basis, and the party invoking the force majeure is the one that has the burden of proof. Second of all, is that the COVID guidelines do not apply to the unilateral termination of a contract, but only to the unilateral variation of a contract prior to a termination. And finally, that nothing has changed in the sense that for unilateral termination, what is applicable is the RSTP, the Regulation of the Status and Transfer of Players, and the jurisprudence of the DRC. Thank you very much. I'll pass the floor to Maya if there are questions.
Thank you very much, Erika. First, the good news. It looks like it's working again, our stream also on YouTube and on the webpage. So we, again, were able to reach around 600 people following us today. So I received a few questions. First one that I would like to share with you and pass on to Erika is coming from a Turkish lawyer. He would like to know if the application of national law depends on whether the parties chose that national law to apply to the contract.
Thank you, Maya. Thank you for the question. Here, no, I would emphasize considering what is specifically said in the COVID guidelines and FAQ, and also confirmed by the DRC, is that for the unilateral termination, it continues to apply the RSTP. So regardless of the choice of law, a national law in the contract, still for unilateral termination, we apply the RSTP. And concerning the national law would be applicable only to the unilateral variation, as we saw, because it's a specific circumstance. And as in the case that I presented, is a case where there is a national law allowing for that variation and also providing the player in that case with income while the contract was suspended. But no, national law will not apply to unilateral termination.
Thank you very much, Erika. I have another one. It's coming from a colleague in South America. He would like to know which reduction to the salary has been deemed reasonable based on the latest decisions that you have mentioned.
So I don't have a specific case here, but you saw in this one that it was a 15% reduction, and this was considered as reasonable. But this is, again, on a case-by-case basis, and it needs to be proven by the one invoking that why the reduction was made and if it's in accordance with the national law or the agreement by the parties.
Thank you very much, Erika. For the ones following us, I mean, if we look always on the side, it's because actually we are in the same room, so it's not that I'm speaking to a mirror or to someone. I know we are all alone, but we are not that crazy yet. So there is another question, and this could be maybe the last one so that we are able to be on time. I get the last one. It's related to force majeure. They would like to know if it is possible that force majeure applies as a general principle, even if the COVID guidelines do not apply.
Here again, I will have to say that it will depend really on the parties and on the analysis of the dispute resolution chamber, whether or not a force majeure situation occurred. We do have many times parties arguing force majeure, but without proper argumentation or evidence. So I don't have a decision where the DRC has recognized force majeure.
Thank you very much, Erika, for this very detailed presentation of the overview of the Player Status Department and the leading cases. We will now soon move to a short break, just for you to remember to stay tuned. And after the break, we will continue with very interesting presentations of the CAS proceedings against FIFA decisions in 2020, Part 1 and Part 2. together with Miguel and Jaime, and then we will have the entire overview about disciplinary and ethics proceedings. So please stay tuned. The best is yet to come. See you in a few minutes. Bye-bye.